Please be seated. Welcome back to the Washington Supreme Court for the second of three cases we're hearing today, our final day of oral argument for the term. It is November 21st, 2024. The case is Jeffrey L. Cockrum, petitioner versus C.H. Murphy, Clark-Ullman, Inc., et al. Respondents. Opening is Matthew Bergman for 15 minutes and Anastasia Sandstrom for 5 minutes. A response from Michael King of 25 and rebuttal by Matthew Bergman of 5 minutes. Counsel, please proceed. Oh, I apologize. We're joined by Justice Pro Tem Vanderwood, as Justice Owens is recused, and Justice Whitener is on the screen to my right and counsel's left. Please.
Good morning, Chief Justice Gonzalez, and may it please the court. Matthew Bergman appearing on behalf of the petitioner, Jeffrey Cockrum. The issue before the court this morning is whether an employer can knowingly subject and expose an employee to a toxic chemical after it knows that other similarly situated and similarly exposed employees have developed disease, and avoid liability simply because it is not 100% certain that the exposed individual will develop disease 100% of the time. Jeffrey Cockrum was exposed to asbestos knowingly and deliberately over a 30-year period at Alcoa. Throughout the time that Mr. Cockrum was exposed, and indeed before he was exposed, Alcoa not only knew that asbestos caused disease, including cancer, but actually observed its employees similarly situated to Mr. Cockrum developing compensable asbestos disease. At the same time, over a progressive period of time, that Mr. Cockrum was exposed without any warnings or respiratory protection and required to handle asbestos on a daily basis.
I have two questions to start. One is, what, if anything, do we have to overrule to reach the conclusion you seek? And two, is there a particular percentage or amount or likelihood of harm that has to be shown? If it's not absolute certainty, what is the quantum?
Well, the rule of law that we ask the court to hold is that under RCW 51-24020, a deliberate injury occurs when an employer continues to expose its workers to an industrial toxin that it knows has previously caused disease in others. We don't believe that the focus should be on the symptoms of the illness, but rather the conduct of the employer, where the employer observes individuals getting sick beforehand, as it did in Berkeley, from the same substance as in Berkeley, where a different cohort of workers was exposed and got sick. Those workers should be allowed to proceed under the deliberate injury exception. It is not a question, and the reading of the Court of Appeals of Walston, we believe, reads out all chronic occupational disease from the intentional injury exception. It was not in the record in Walston, but the record in this case establishes clearly that there is no form of chronic industrial disease, including cancer, that is 100% likely to occur in every instance where every exposed worker develops disease. Now, with respect to Your Honor's other, yes?
Oh, if you're going to answer his question.
Okay, with respect to Your Honor's other question, the holding in Walston, that Mr. Walston, that summary judgment was properly granted in Walston. This court, I don't believe, needs to reverse that holding. The evidence that came forward in Walston was not the evidence that we had here. In Walston, there was no evidence of contemporaneous disease of similarly exposed workers that Boeing knew about, and this court's other holding that subclinical disease, the subclinical cellular disease is not compensable under a certainty test, again, does not need to be disturbed. I think what the court needs to clarify is paragraph 12 in Walston, where it seems to suggest, on one hand, that Berkeley is controlling, and on the other hand, that you need to have 100% certainty that the individual plaintiff develops disease. That statement in paragraph 12, we believe to be internally inconsistent, because in Berkeley, the plaintiffs were not the same people that had been previously exposed, and not 100% of the exposed workers in Boeing exposed to the phenol resins in Berkeley developed disease. We don't necessarily, so the question, Justice Gonzalez, is to the extent that the court intended to exempt all chronic industrial diseases from intentional injury analysis in Walston, that would need to be overturned. We don't believe that's what the court intended, but other people have different points of view on that.
And I think Justice Messon was going to help me ask you to clarify the first question about if there's a quantum. And so if there's certainty or virtual certainty that someone will be injured, does it have to be a certain percentage of the class? Is there a quantitative aspect to this?
It's certainly not.
Let me add one more bit to the question. If there's a 0.05% likelihood and the employer knows about it, is that enough for virtual certainty if you have 100 people, maybe not even one of them will get it? What do we do mathematically?
Okay, first of all, and I think as this court held in Berkeley, we're talking about constructive certainty, first of all. Secondly, I think the test has to be basically a one-bite rule. It can't just be probabilistic. I think that the test needs to be you actually have to observe individuals developing sickness from a particular toxin. And I think if you, in order for the intentional injury, well, in order to create at least an issue of fact on whether or not the plaintiff should be allowed to go forward on an intentional injury claim.
Can I ask a clarifying question about that? Because Berkeley was, a different type of exposure, different kind of injury resulting from exposure that could be observed in the time frame with the employees at that job site. When you say a one-bite rule, are you saying that an employer must have observed its employees developing cancer from asbestos exposure, or must be certain, must know that in similar settings, employees who suffered this exposure developed the cancer?
I think the similar settings test, Your Honor, goes a little too far into the negligence, into the should-have-known kind of situation. I think that in this case you had, I don't think it has to be cancer per se, but I think that in this case you had, through this annual monitoring, watching a human tragedy unfold as workers year after year were being tested and were showing greater and greater symptoms of exposure.
But I guess here's what I'm getting at, and maybe this is, I want to be clear what your rule is and why it isn't a substantial certainty or gross negligence type of test, because it doesn't seem very real world to say that given what we know about asbestos exposure in 2024 and forward, the employer has to observe its employees suffering the disease cycle that thousands of people have suffered across the world up to this point. But that seems to be the rule you're advocating for, and that seems to be trying to get around case law rather than addressing the real world scenario.
Well, that's true. I mean, I would love to have a rule of law such as you just espoused Justice Stevens, but I also respect the precedent of this court, and I also understand that the intentional injury exception is supposed to be narrow. And the grand compromise is still around and needs to be upheld. So, I think that, for purposes of this case, a ruling that would basically impose a one-bite rule where the employer actually has to observe its employees similarly situated, developing disease, would be sufficient and certainly would create an issue of fact that would allow this case to go to trial.
So, Counsel, is that something that would be satisfied on your facts?
We believe it would, Your Honor, for the reason being that they performed annual monitoring and observed compensable asbestos disease, not what we had in Walston, which was, subclinical cellular stuff, but we had actual individuals that were similarly exposed, doing similar work to Mr. Cockrum, developing compensable asbestos disease, pleural plaques, and asbestosis, and there were cases as well of mesothelioma. And if you look at those internal documents, if you look at what the company doctor was looking and seeing, that is to me the same thing in Walston. The only difference, the same thing in Berkeley. The only difference being that in this case it is a chronic as opposed to an acute injury. Obviously in Berkeley it was an acute, immediate injury resulting from the phenyl resin. In this case, it was chronic. But but under the Court of Appeals holding, all chronic industrial diseases have been written out of the intentional injury exception. There is no form of cancer whatsoever that is 100% likely to occur based on exposure. And that is the holding that the Court of Appeals rendered in upholding the summary judgment in this case.
So what I'm not sure I'm understanding about your argument is if your argument then is that the court should reverse that holding of the Court of Appeals, but preserve Walston, how you do that?
If the court wants to overturn Walston, I would be persuaded. I'm just saying you don't have to overturn Walston in order.
But what I'm not understanding is how is it that we don't?
Well,
what's the need? I mean, you're threading a needle and trying to figure out what the
sure.
How you're doing
The needle in the haystack, so to speak, or the needle to be threaded, so to speak, is paragraph 12, which can be interpreted two ways. It can be interpreted to say that you have to have 100% certainty that the plaintiff himself or herself will develop asbestos disease based on their exposure. To the extent that the court meant in Walston to hold that, that holding is inconsistent, we believe, with Berkeley, inconsistent with Article 2, Section 25 of the Washington Constitution, and inconsistent with this court's recent ruling more recent ruling in Martinez that workers have a fundamental right to safety. On the other hand, if you look at paragraph 12, it says Berkeley is binding on this case, and so if Berkeley is if Berkeley is binding on Walston in that manner, and the facts in Berkeley were that the plaintiff was not the same individual who'd been previously exposed, it's simply not a question of overturning Walston, but clarifying the language. I will leave it to others to say, to decide whether or not a full reversal or clarification is in order. But I believe, Justice, it is possible to thread the needle, so to speak, so that certainly the disposition of Walston need not change, because the language in paragraph 12 was not essential to the holding that summary judgment was appropriately granted in Walston. So should the court be inclined to overturn Walston, that would be a good result, but the court does not need to do that in order to conclude that the plaintiff in this case has established sufficient evidence to create a fact issue of whether Alcoa had actual knowledge that, and this is really important if you look at the language in Berkeley, actual knowledge that an injury was certain to occur, not that the plaintiff's injury was certain to occur.
Counsel, in Berkeley, remind me, did every single person, was every single person exposed injured as well?
No, they were not, Your Honor.
Right, so it doesn't seem like Berkeley necessarily required that an individual worker would necessarily have been injured by this, but that the vast majority of the workers were, and therefore knowing that it was intentional on Boeing's part not to change their process.
Well, and Justice Madsen, you pointed exactly why I'm perplexed by the perplexing nature of paragraph 12, because on one hand, the court in Walston suggests that everyone has to get sick. On the other hand, they circle back and specifically say Berkeley is binding on this. So I think Your Honor has pointed out the key fact in Walston is, the key fact in Berkeley is that not everybody got sick, and that the plaintiffs in Berkeley were not the plaintiffs that had previously sustained the injurious exposure that gave rise to the prior knowledge.
So that leads me to where I unfortunately tried to interrupt your answer to the Chief, but that is, so what percentage? I mean, is it like a more likely than not standard that this person will develop based upon the history of other employees in that same situation? Or how do we measure when it's becomes deliberate because there's such an overwhelming number of people or underwhelming number of people? Sure.
In Justice Madsen, I don't think that, kind of looking at the statistical probability of a particular type of cancer, the sliding scale is the appropriate standard. I think.
Well, I don't know. Does it have to be cancer? I mean,
no, it does not.
It just has
no.
to be injury.
Correct. I think that to me, it's where, to me the test is, and the best example is what we have in Berkeley. The workers were, you actually saw people having a physical, sick, developing disease based upon exposure to this product, this substance, and you knowingly subject other people to the same product. I think that is, and I think that gives rise to the level of certainty that preserves the grand compromise, but does not allow unscrupulous workers to, unscrupulous employers to hide behind the WII to abrogate the constitutional right that workers have to a safe workplace.
Counsel?
Yes.
That brings me back to just something Justice Stevens asked you, and that is, with what we know now in regards to exposure to asbestos, why would we have to have the employer have specific knowledge in regards to observing an injury within their employment realm? Why would we need that, given what we know now?
Well, that's what Berklet says. And,
yes, but
yeah.
You're saying you don't want to overturn Walston, and I'm trying to figure out why not. Why aren't you asking us to do that? As opposed to clarifying it?
Because I want to ask, I know that overturning a decision is a bigger ask than clarifying it, and that I don't believe you need to, but in order to grant the relief that I'm seeking, and so I'm trying to be more minimalist in what I'm asking this court to do.
Do you think that under Berklet, or the deliberate injury exception generally, relates to causation? Because there is some discussion in the brief about, gee, if it's 100% certainty, that's not how disease is accepted inside the IIA, and causation, maybe it goes a little bit to Justice Madsen's question. Do you see these as completely discrete issues, or do you think there's a connection to meet the threshold you propose for deliberate injury?
I think there is a threshold, but I think that threshold is best, that's an issue of fact. I think it would be hard for me to set forth a legal standard for a legal threshold. I think that's an issue.
I guess let me ask it this way. Is the fact that diseases are accepted as industrial injuries on something less than 100% certainty, does that relate at all to how you would have the court analyze deliberate injury in a disease case?
Yes, I would, Your Honor, because there's no chronic industrial disease that is ever certain, and so I think it would be appropriate, again, to focus on the employer's knowledge and the employer's conduct and what they knew and what they saw. Thank you.
Thank you. Next, we'll hear from Anastasia Sandstrom.
May it please the Court and Chief Justice. I'm Anastasia Sandstrom, Assistant Attorney General representing the Department of Labor and Industries. When an employer intentionally exposes its workers to a hazardous substance, the employee should be able to hold that employer accountable for occupational diseases, just like industrial injuries. The Department of Labor and Industries has filed an amicus brief because it's concerned about workers with occupational diseases and that they should be protected just as much with industrial injuries. With respect to the rule that the Department of Labor and Industries asked this court to adopt, we have two aspects of it. The first is the court should hold that the deliberate injury occurs when the employer continues to expose its workers to industrial toxins that it knows causes occupational diseases.
So as to the, let me stop you right there, as to the actual knowledge prong, which I think is how it's characterized, your colleague suggested the one bite rule, meaning there had to have been one incident that gave rise to an injury to satisfy the actual knowledge prong. Do you agree with that?
No, Your Honor. What my second point was going to be is the level of certainty should be substantial certainty, which I recognize this court didn't reach in Berklet, but I think the dissent in Walston makes a convincing case for it under the restatement of torts. And so under that, it would be a factual issue of what substantial certainty is. And the restatement of torts is very useful because it says that as the probability that the consequences will decrease and it becomes less than substantial certainty, the actor's conduct loses the character of intent and then becomes recklessness, negligence, etc. So this is a very well-defined area of the law. There's cases in other jurisdictions that have used the substantial certainty test.
Though, can I ask, I mean, you say Berkeley didn't reach it, but didn't Berkeley reject it?
Correct. I'm sorry.
So you're asking us to overturn Berkeley?
Yes, I think that both Walston and Berkeley are both harmful and incorrect. And I think what's changed, and besides the fact that this court does not let decisions stand that don't provide justice for a huge swath of people, and that's people with chronic occupational diseases, the court in Martinez-Cuevas examined Article 2, Section 35, and found that there was a fundamental right for workers for workplace safety. The statutory provision provides for the protection of workers. And we argue that this means that the lens of which you examine the statute need to have a heightened lens to protect workers, and that should be the point of the analysis and why we cited.
Though, can I ask you, in Martinez, that was relied on to find unconstitutional a legislative choice. How does that play in here? Because really, aren't we trying to just interpret a legislative choice? They could change this tomorrow.
Correct. I think one of the imports of Martinez-Cuevas is that it did examine Article 2, Section 35's importance, and it characterized it as a fundamental right, which is very important. And so when you engage in statutory construction, the Industrial Insurance Act is already interpreted to benefit workers, but it should be also interpreted in light of this constitutional provision that shows just how much it is important in Washington State. And here we have an employer who...
Counsel, before you leave that, what about the grand compromise? Isn't that a sort of also at play in here? Because it's not just the workers' rights, it's the rights of the employers, right? So they may or may not be negligent, or there's no requirement to prove that they're negligent, but they have to pay for the injury regardless. So what is that?
The grand compromise is important, but it covers accidents. The legislature, as part of the grand compromise, said that retained the common law with respect to intentional actions. And so if you have an employer like Alcoa who knows how bad asbestos is because of medical literature in the 50s and 60s, has yearly testing that shows employee after employee getting various diseases caused by asbestos, doesn't provide respirator to this employee, but did to other employees, the Department of Labor and Industries feels that if that sort of behavior can be tolerated, it really puts workers, particularly workers in disadvantaged circumstances that don't have the bargaining power to have their employer treat them right. I see my time is up, and I don't want to get into counsel's time, so we ask that you reverse. Thank you.
Thank you. Michael King, please. Response.
A new device here, so I'm going to push on this and bring the table up. Sorry for taking the time. May it please the court, my name is Michael King, and along with Jason Anderson, we're from the Carney Badley Spellman firm, and we're here on behalf of the defendant and respondent, Howmet Aerospace, which I will refer to by its historical name, the Aluminum Company of America, and even more familiarly, Alcoa. If I may, well, I was planning to take a minute or two to summarize what I think is most properly before the court and not properly before the court. But the court's questions just surface all of that. So I'm going to start by engaging with the court's questions and the response of counsel. And I want to start by stating a fundamental premise. We're not here in the first instance getting to interpret the intentional injury exception. That has been interpreted over and over again, including in Berkeley, including in Walston. So really, the only way that the plaintiff can get around the dismissal of his case is persuading you that somehow, somewhere, there's a way that you can, on a principled basis, read Walston so that there's an open question, and then read Berkley so that there's an open question, and on that basis, overrule the Court of Appeals and the trial court and reinstate the plaintiff's case. And the problem is, you don't have it. Let's start with Walston. Let's start with the attempted factual distinction. The suggestion that Boeing had no clue that its employees were being affected adversely by asbestos at the time of Walston's exposure. Now, this claim has been made repeatedly in the case, and it's just been repeated to you right here at this dais. But in fact, as the record from Walston conclusively establishes, the briefing in Walston, which has been before the courts, the clerk's papers from Walston conclusively establishes, Boeing darn well knew at the time of the Walston exposure that some of its workers were developing disease because there were worker compensation claims that were being submitted to Boeing. And those were in the Walston record. And an employer knows about worker compensation claims. So Boeing was aware of the fact that its workers, some of them, were coming down with asbestos-related disease. But it's also an irrelevant fact because this court in Boeing cut through that and said the focus must be on the individual worker. So let's do an exegesis of the opinion in Boeing. And there are three things that you need to look at. It's not Westlaw paragraph 12. The first thing you need to look at is in the statement of facts. This is Westlaw paragraph 4. And that's where Justice Owens, for the majority, made a point of pointing out that the plaintiff's experts conceded that asbestos exposure is not certain to cause mesothelioma or any other disease. The second thing you need to look at is the issue statement, paragraph 6. Now, one of the things I've always admired about the way Justice Owens writes her opinions is she tries to make them absolutely clear. So she always has this issue statement. Look at this issue statement. Has Walston raised a question of material fact as to whether Boeing had actual knowledge that he was certain to be injured by the asbestos exposure? Not the fact that there might be a group of workers out there and there was so much asbestos exposure going on that some of them, but not necessarily the plaintiff, were going to come down with the disease. No.
So can I ask as a question there? Because one of the arguments in the briefing is that's the drift between Walston and Berkley, that Berkley didn't require the showing of certainty that the specific plaintiff would get the disease, but the certainty that employees would be injured because it was broader. So can you address that?
I will address that. But I think we will agree that the issue statement makes very clear, as the court is framing the issue as, can this party show that the employer knew that he was certain to develop asbestos disease because of the exposure involved? And the final point I would refer to, and then I will go to Justice Stevens' point about Berkley and the so-called drift, is found in the conclusion, paragraph 15, applying the standards set out in Berkley. There's where they allege is the drift. We'll get to that. We conclude that Walston has not raised a question of material fact as to whether Boeing had actual knowledge of certain injury resulting from the asbestos exposure. Therefore, Walston has not shown that Boeing deliberately intended to injure him and cannot pursue a claim outside of the workers' compensation system. Now, two things about drift. First, I'll talk in a moment about what actually was at issue in Berkley and what the actual holding was in Berkley. But more importantly, we've already done this. This court has interpreted Berkley a certain way for asbestos cases. We're now 10 years from that decision. There's this concept of legislative acquiescence, which is never discussed by the petitioner in his briefing. Or remarkably.
Were you going to get to Justice Stevens' question? I'm kind of interested in the answer.
All right, then I will get right to Justice Stevens' questions. And there are 2 points about what was involved in Berkley. One, factually, yes, it was a matter that all of the complainants were known to be going to be injured because this was a re-injury circumstance. And the briefs in Berkley, which are in the record, make this very clear. You had this rosin The workers were exposed. They were coming down with conditions. They went to the manager. They said, you got to do something about this. Don't send us back in. And they were sent back in. And what Justice Talmadge said for this court was, it was a summary judgment case for Boeing. And what Justice Talmadge wrote for this court was, there was an issue of fact. The jury could find that these workers were certain to be injured. Now, there's a second important point here where we have to link up the facts of Berkeley to the rationale of Berkeley. You have been told that what you should do is by reading Walston as not having had certain evidence in front of it, which it did, but let's assume for a moment it didn't. You should take that and then you should adopt this constructive certainty approach, which is essentially the notion of if the plaintiff can prove I was exposed, my colleagues were exposed, my fellow workers were exposed. Some of us were sure to come down with this disease, in this case asbestos. Maybe not me, but some of us were sure to come down. Then under those circumstances, then I get to state a case. Well, the problem is that is exactly what Justice Talmadge, writing for this unanimous court, said we're not going to do. And I am reading from 127 Washington 2nd at 866. Oregon has adopted a view of deliberate intent to injure that focuses on the question of whether the employer had an opportunity consciously to weigh the consequences of its act. And here's the key phrase. And knew that someone, not necessarily the plaintiff specifically, would be injured. Doesn't that sound what they're arguing for? That you should adopt as an interpretation? We decline to adopt the Oregon conscious weighing test. We are mindful of the narrow interpretation Washington courts have historically given to RCW 51.24.020 and of the appropriate deference 4 generations of Washington judges. This was in 1995. I think we're up to 5. 4 generations of Washington judges have shown to the legislative intent embodied in RCW 51.04.010. So when Justice Montoya Lewis asks, how do you preserve Ralston? The answer is, you don't. You would have to overrule it. And how do you preserve Berkeley? You don't. You would have to overrule it, which brings me to the heart of this case. We're not dealing with a Stranger Creek situation. We are not dealing with a common law rule. We are not dealing with a situation where you, in charge of the common law, get to revisit one of your decisions and ask whether it's wise or prudent or whether it's worked out. We are dealing with a question of statutory interpretation. You have done the statutory interpretation. You have done it many times in this area. Indeed, in 1976, Justice Utter in the Foster case was asked, the court was asked to do this kind of liberalization and relaxing, and Justice Utter said, no, we're not going to do that. This has been around for 50 years. It's presumed that the legislature knew this. And moreover, we know the legislature has amended this statute many times, and they've never touched this section. Well, since 1995, the legislature, the legislature is very interested in the IIA. We are not dealing with a statute which got passed 60 years ago and nobody has looked at it since in the legislature. It's never been examined. It's never been amended. Since 1995, we have an appendix on this point attached to our brief in answering the amici. This statute, the IIA, has been amended 158 ways in every single legislative session. And yet, the legislature hasn't touched the intentional injury exception. Now, the department comes to you with an amicus brief and raises the constitutional...
Counsel, before we go there, I just had a question. Are you acknowledging that in relation to the actual knowledge prong and items certain to occur, that in essence it takes off the table any latent claim that a plaintiff might have? Is there any way a latent claim can be preserved within the context of Walston?
An asbestos claimant?
Yes.
Absolutely not.
How about any other?
Other substances? like other toxic substances?
If it's latent.
Well, the answer is we don't know how this is going to work for other substances until we apply it. If the substance is like asbestos, well, then that would be the same outcome. You have had the suggestion made that if you uphold Walston, then you're going to create this situation where every employer who employs a toxic substance in the workplace knows that they can get away with injuring the workers, and they'll have no accountability under the intentional injury exception. We don't know the qualities of each substance, and as the toxicologist Amici pointed out, what you do is you develop a record about a substance, and then you determine whether the certain injury test, the first prong of Berkeley, can be satisfied. So you do this substance by substance. That's called good science.
So, counsel, what you're suggesting then is that workers can be exposed to a new substance, old substances, and they don't have any claim until that scientific analysis has been done over likely decades. Am I understanding you?
Actually, I think that's a problem for the employer. Because if they introduce a new substance and we don't have an answer as to whether, well, if we have a substance, it's a new substance, it's introduced. First of all, the workers get workers' comp. That's the grand bargain. All of the asbestos employees who suffered exposure are getting workers' comp. They have lawsuits against others, but they get workers' comp. That's the grand bargain. Why are we bothered by this idea? That is the policy that was arrived at in 1911, and it's been affirmed over and over again. And it was affirmed in Berkeley, and it was affirmed in Walston. Now, all you need to do is say—
I think the reason we're bothered by it is the language of deliberate intent. So I keep thinking about new industries like vaping, where there's no regulation about what is in what creates the vapor. So the workers who are creating those, and I know much of that happens outside of the country, but for the sake of this analogy, let's say they're in Washington. We don't know what's in it. They're repeatedly exposed to it, but they have what it sounds like no potential for a claim until 30 years down the road they develop some sort of illness.
You know, Your Honor, you don't know, I don't know.
But my analysis is correct under your theory, is it not?
But what we're dealing with is the legislature's policy. What we're dealing with is the legislature's intent. You ruled what you did in Berkeley. Done deal. 29 years ago. You ruled what you did in Walston. Done deal. 10 years ago. And this is a statutory interpretation question. You've raised, I agree, a question of significant public concern. But at this point, you don't go back and say, well, now we've got a new situation, so we're going to undo our interpretation.
So can I ask you more precisely, because you said this is statutory interpretation, not common law rule. Are you saying that as a category of cases, any incorrect and harmful analysis is inapplicable to a statutory interpretation case?
And that's exactly what was said in Deggs. In Deggs, the point was made that you were using the Stranger Creek analysis because those old opinions that had put this restrictive gloss on the wrongful death statute didn't do statutory interpretation. They just applied the gloss. So you were free to employ the Stranger Creek analysis. But when you are interpreting the language, and I agree, Justice Montoya-Lewis, if you go back and you look at this language, and if it were a first instance analysis, and this were the first time you're doing this, we're going to travel back in time. It's 1922, it's Dethone, and you're looking at this for the first time, you might arrive at a different conclusion, but you didn't. And year in and year out, the legislature knows about your interpretation, knows how to amend the statute, does many amendments, and knew about Berkeley, knew about Walston. It's implausible to think that the legislature wasn't aware, and you have this principle, and it's a separation of powers principle, Justice Stevens. It's a separation of powers principle here, because your job, when a positive law enactment comes to you and the legislature has decided, and that's the embodiment of their public policy, your job, of course, is when a case comes in front of you, you interpret the language to effect legislative intent. Well, you did that in Berkeley. You did that in Walston. And under your legislative acquiescence jurisprudence, and there are many cases very recently, you have been applying this rule consistently and very recently. What you're being asked to do here, once you realize there isn't a record out, there isn't a way to parse Walston, there isn't a way to parse Berkeley to allow this case to survive. What you are left, yes, Your Honor.
I'm trying to follow you and this argument. So I know what Berkeley and Walston says, but let's deal with the practicality of this situation for the trial level court. Will it then be up to an expert to say that the injury is certain to be caused as to the particular individual? And if counsel presents that evidence, they overcome the summary judgment motion, which is, I believe, what occurred here.
Yes.
And then it goes on to be a credibility issue at trial? How would that work?
Well, presumably, if...
Because I know here the expert indicated that, I guess, mesothelioma it's never certain to be the cause of the disease.
To an individual, that's right. Which is why...
But what if we get an expert that says something else?
Well, now that's a very interesting question. So suddenly the science changes. And my answer to that would be, if the science changed, this is exactly the answer I gave in front of the Court of Appeals, if the science of asbestos changed, and suddenly there's a school of thought based on some studies. So we've got the functional equivalent of Dr. Selikoff, a pioneer who comes in and says, you know, we can identify that employers would have known with certainty because of this, that, and the other thing. Then I think what would take place is a hearing on that. There would be a challenge to that opinion, perhaps, but there would be a hearing, and that record would be developed. And then the judge would decide whether to let the case go forward, because while we've got a genuine issue of fact here about whether, in fact, we can say it's certain that this person was going to develop mesothelioma. And that case would go up, and it would come in front of you, and that would be a changed circumstance, a different factual record. And that would mean that asbestos would no longer, if we accepted this changed circumstance, fit the Berkeley rule. There wouldn't be a problem with having to say, well, Berkeley is invalid, or even Walston. You would simply modify your Walston holding and say, well, now we've got new science.
Can I drill down on your answer? Because as you phrase that, you say the science would evolve so that we could say an employer would know for certain. So I want to be clear, you didn't, in answer to an earlier question, you weren't accepting the one bite notion. So it sounds like to me, am I clear in understanding that if there were testimony that an injury was certain to occur and to the individual and the employer knew of the exposure, you're saying the employer's knowledge of similar settings would be sufficient if the scientific path was exposure to substance A causes this disease.
If the employer knows that this individual is certain to be exposed,
well, no, but I'm saying, can you put
of science,
right,
which shows that when I expose Joe or Jane, Joe and Jane, they're both going to be.
Got it. So it doesn't have to be that Joe and Jane were both employed. If there's science saying people exposed to this get this disease, and next step, plaintiff was exposed to this, that would meet deliberate injury in your view.
There would be a dose issue, but presumably the science would show that.
I'm not asking this precisely. You're short on time. It's a smaller it's probably a smaller question than you're trying to answer. You do not agree with the plaintiff that you'd have to show workplace-specific prior injury. You think it would be sufficient if the science showed the certainty and we knew this plaintiff had been exposed?
Yes.
Okay.
Yes, I'm satisfied with that. To answer your question, Justice Whitener, we're at a point now with asbestos where the science is you cannot say that Joe or Jane, if they're exposed, was certain to develop mesothelioma. And this court in Walston said, then that's that. Applying Berkeley, those claimants in the asbestos field, they're going to settle for workers' comp. They're not going to be able to sue in tort as well. But that is the grand compromise, after all. I mean, this...
can you address whether you think under Martinez, then, that would render the statute susceptible maybe to a privileges and immunities claim for disease?
I'd be happy to, and that was actually the very next thing I wanted to go to. And I want to make 2 points about the department showing up here and raising the issue in an amicus. The department should not be showing up here and interjecting this issue for the first time in an amicus. We have extensively briefed why that is very bad process. That process exists for a reason. It exists to ensure that this court gets issues presented to it in the best possible posture for decision. And one of those fundamental rules is issues should be raised in the trial court and worked out in the trial court. And amici are not supposed to be bringing issues like constitutional questions and interjecting them into the case. And here you've got the department. And I want to make a couple of points about the department. This is the agency that has responsibility for administering workers' compensation and WSHA, the safety regulations as well. And they have been silent. Berkeley's been out there for 29 years. Walston's been out there for 10 years. Martinez's been out there for 4 years. And they didn't take the opportunity to appear as an amicus in the trial court in this case. Surely they are aware of this ongoing series of litigations. No, they have been silent. And they come here and they say, well, you should take on this constitutional question. This is a flagrant violation of good process. And process matters. And for that reason, number one, you should say, no, 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 we're not taking on this issue at this time. This is not the way you bring a constitutional issue to us. Another case, we'll put a footnote, we'll acknowledge it. The second thing I want to point out is all you need to do is look at Martinez and the intricate structure of the opinions to realize that there are some principled problematic problems that immediately surface with the idea that you're going to take Martinez and you're going to blow up the grand compromise. You're going to say, oh no, Berkeley and Walston can no longer stand because obviously there's a violation of Section 35. Really? That's obvious? So the court is now going to basically become the arbiter of last resort on question after question of the details of regulations. You're going to undo the grand compromise on the basis of that decision when in fact, closely analyzed, that decision is a case about race and ethnic origin discrimination. There was a health and safety law, the Washington's wage and hour law, which foolishly imported all the racist structures from the federal statutes from the 1930s, and we know why those happened. All of this was laid out in the Chief Justice's concurrence in Martinez. And so the end result was a health and safety statute was not doing its job, and a discrete and insular minority was being discriminated against. But again, and if I may sum up here, you shouldn't reach this issue. You should tell the department, do not come in front of us. Just because you're a state agency doesn't mean you get to ignore all of these fundamental processes about how issues get raised. So I'd give that the back of the hand and say, bring that issue before us properly. And you should enforce your decisions, which have long ago become the legislature's intent. And any change to that has to be done across the way, across the plaza. And those who don't like the present rule need to take their case for that change there. But the bottom line of this case is you affirm the Court of Appeals and the trial court which honored your decisions, which are the controlling decisions in this case. And I thank the court for its time and attention.
Thank you. Rebuttal, please.
Well, it's certainly over for Mr. Cockrum. You just heard a rule of law articulated that would allow an employer to hire itinerant day laborers, have them strip asbestos without any respiratory protection, assuming they don't even know what they're doing. This same conduct, people are serving federal time for violation of the Clean Air Act, and you're hearing that that does not give rise to civil liability. Under the rule of law that my colleague has articulated, you could have the workers at Fukushima nuclear plant who were tasked with cleaning up liquid plutonium. They would be precluded from bringing a case because it is not certain that every individual exposed to plutonium gets leukemia. Now, you've heard that
Are there other protections, though, for the workers, such as WSHA, for example, when you have an employer who engages in this conduct? I know certainly that if they don't, provide the proper equipment to protect their employees, they definitely are subject to penalties and maybe prosecution.
Well, as this court held in Stute, the civil justice system has a very important role in regulating workplace safety. The fact that Mr. Cockrum worked with asbestos for 30 years without any respiratory protection indicates that to the extent that he relied on WSHA to protect him, that reliance was misplaced. Let us be clear, though, in terms of the factual issue that was said, what is not certain. The evidence in this case, and this was not evidence that was before the court in Walston, the evidence in this case, unrefuted from Dr. Haber, is that there is no form of occupational cancer that is certain to manifest in every exposed worker. What you have heard is a rule of law in which all cancer claims are ipso facto denied the ability to make an intentional injury claim, notwithstanding how intentional, how heinous, how craven the conduct of the employer was in a particular instance. Now,
can you tell us how it is that we can reach the conclusion you would like us to reach without overturning Berkeley?
I don't believe you would have to overturn Berkeley because we're not talking about restoration or resuscitation of a substantial certainty test. We're simply saying that the facts here are completely analogous to Berkeley. The only difference is that there was a chronic injury, a chronic injury as opposed to an acute injury, that instead of seeing people gasping on the shop floor, the doctor saw their radiographs and saw their pulmonary function tests and saw that they were that the alcohol workers were developing disease. So I don't believe that.
Why isn't that a substantial certainty test?
Well, no. I'm just saying, you've been asked. It's not a substantial certainty test. It's actual knowledge of a certain injury and willful disregard. It is the same. That what occurred here is Berkeley in slow motion. That in slow motion, the only difference is that because it wasn't an acute substance, it was a latent substance. It was over time. I want to focus, though,
but
that
Berkeley, the employer could see the effects of what the exposure was.
And if you look in the record, Justice Mattson, in this case, the employer did see. They saw the records of the doctor saying this person is developing asbestosis as a result of asbestos exposure in our plant, and it's getting worse year to year. It's even worse than Berkeley because they're seeing it happening over time, and they continue to put them back. I want to focus the court on RCW 5132-180. It was not addressed by my colleague, but it is the requirement. We talked about the legislature. The legislature has made very clear that occupational disease is to be treated equally to acute injury. And that is the legislative dictum, and that is the requirement. In what you are being asked to do, and what the Court of Appeals essentially did, was found that there is a differential standard under the Intentional Injury Act. That occupational disease, which we are statutorily required to treat equally, I have one result when it relates to intentional injury, and acute injuries, physical injuries have another. That's not what the legislature required. That's not what the court can do. The court can and should ensure that where an employer knowingly exposes a worker to a hazardous substance, having seen other workers drop dead from the same thing, that worker, that employer cannot evade civil liability. Thank you.
Thank you to counsel for your briefing and arguments. The case is submitted and we are in recess until 1:30.